SJC-11288, Commonwealth versus Winfield.
Let's proceed.
Good morning. May it please the court. My name is John Albano. I'm here with John Reinstein for the appellant, Steve Audette. In November of 2007, a former Somerville police officer, the defendant in this case, was convicted of rape and assault and battery on a 2-year-old. He was convicted, received a life sentence and 2 concurrent 9 to 10-year terms. There were 3 days of evidence at trial. 8 witnesses testified. The victim was too young to testify. She did not testify. So the witnesses were 2 police officers, two doctors, a DSS supervisor, the victim's mother, and the victim's maternal grandparents. The trial was public. It was covered in the press. There was no impoundment order. The transcript is public, and all of the exhibits are public.
When you say the transcript is public, has the transcript been redacted in any respect? Name of the victim, nothing redacted?
No.
How is that possible? Isn't that against our rules?
I think not for this reason, Your Honor. There is a statute, I think it's 94C, that presumes that the names of rape victims will be confidential. I shouldn't say presumes, says they will.
Yeah, that portion of the court record with the name of the victim shall be withheld from public inspection.
Right. But for, I believe it continues and says, but for order of the court. So I have there's 2 responses to that question. One is, certainly as a practical matter, that's what happened here, because if we go to the appeals court, the transcript's there. I looked at the transcript last night. The name is there. The second practical problem with the statute as drafted is that if the presumption that the statutory presumption that it shall be confidential unless the court orders otherwise is very close to the statute that was reversed by the Supreme Court in Globe versus Superior Court that said flatly, you cannot attend the portions of a rape trial involving a juvenile victim. So the answer to your question is, it's out there. It's in there now. I saw it last night, and it's in the record.
Let me ask you, though, about you speak of this as a somehow an official court record or a court record, and I have some questions about that, because we're not talking about an audio recording here. We're not talking about audio recording equipment that captures everything that's going on in the trial. We're talking about what a voice recorder where the stenographer is just repeating testimony. And so that's correct, right? We're only talking about the voice recording.
I think that's not correct, Your Honor, and I think I probably should have been more clear about this. There is an actual tape recording of the proceedings.
Of the entire
That is the
proceedings.
request.
That's what you want.
Yes.
It's what
yes,
the
Your
voice
Honor.
recorder uses as backup.
Yes.
Is that right?
Yes, there's an actual tape recording and that's what Mr. Audette requested.
Oh, I didn't get that at all.
That's
That
when
doesn't come through.
that's what the request was made to the Superior Court back in July of 2011.
So you're not asking for the voice recorder's raw.
Correct.
The point, as
whatever.
I understand it, is that what you want is actually tonal inflections of the witnesses who were captured on that backup tape.
That's precisely correct.
For the purpose of the documentary, because it will give it life, as compared to using an actor who would be reading from the transcript.
Yes, and Mr. Audette's request to the Superior Court said, in essence, just that.
And how is that not a form of entertainment or commercial enterprise that wouldn't require you or entitle you to have that?
Well, it's not. It's certainly there is.
Use of it. You're taking these bits and pieces, dramatizing them, focusing on the moments when doctors were unable to speak, those things.
Yes. Well, there's I'm not suggesting that there is not a commercial aspect to making a film. There's also a commercial aspect to printing a newspaper and selling them. But it's precisely the same First Amendment analysis. This is a form of communication that is designed to inform the public and to assist the public in evaluating what happened at a trial. It is the very best evidence of what happened at a trial. And for all the reasons that there are so many appellate cases that say, we just have the bare record, those credibility determinations need to be made at.
But that's when we're really talking about what the jury's function as compared to the appellate review function, right? I'm just trying to explore exactly where we are in this new realm of, and certainly taking your point, there is a value to art and conveying what happens. But what is the value here? You're saying that the public should have the chance that the jury had to judge the credibility of witnesses?
Absolutely.
And make their separate determination?
Absolutely. That is the reason why underlying the public's First Amendment right of access to attend trials, that is the reason why even if the trial was open and you went to the trial, you have a public right of access to the transcript.
So they can judge that the outcome, or they can judge the fairness of the process to make sure that process was
Justice
observed.
Frankfurter wrote one of the most stinging articles I have ever read about Sacco and Vanzetti, and he did that by reviewing the trial record after it occurred, and everyone has the right to do that. That is what underlies the right in this case, and there will be no better evidence than the tape.
Let me ask you, though. Okay, thank you. Let me ask you, though, when I don't know what's on this backup recording, is it more or different than what you would be able to hear if you were in the courtroom as a spectator? I don't know what this recording picks up. Does it pick up conversations that would not make it into a transcript? Has anyone listened to this? Has there been any kind of an in-camera listening session to what's on this audio so that we actually know what we're talking about here? You know what I'm saying? Because I don't think you're entitled to more than you would get if you were sitting in the courtroom as a spectator.
Well, here's what we know. I certainly haven't listened to the tape. The request for the tape was denied. We know from the Superior Court proceedings that the request was made and that the answer was, it is not a judicial record, therefore denied, and even if it is a judicial record, the privacy interests of the victim and her family trump any First Amendment right of access. There was no suggestion that sidebars were recorded. There was no suggestion that conversations between counsel were recorded. That is the basis for the ruling. There is not an affidavit, not a statement from a psychiatrist, not a social worker. There is not a shred of evidence, a la Barnes and Martin, that was presented that said anything in this tape in terms of the content, the information, is different than the four corners of the transcript. That is the basis for the court's ruling, and those were the two legal errors.
So let's talk about the right of privacy for a minute. Let's say you prevail here. In every case, then, the tape recording is available to the public?
Well, we say, Your Honor, that the same rules would apply to the tape, same rules that apply to the transcript, that apply to every judicial record, that will apply to, is it Court Smart that's going to be taping all of these proceedings? Very same rules, which means that if there is a compelling state interest, and privacy is one, then portions, for example, of a tape can be denied access to the public, just as portions of a transcript. But there does need to be evidence. There does need to be at least an affidavit, as the Martin Court and the Barnes Court have said. And there has to be a showing that, for example, let's take a look at this case. This is not a case where a victim testified. This is not a case where the tape there's any suggestion that the tape has some information that is not already in the very public record. So when we evaluate the privacy interests here, we have to say everything here is already in the public record. And I would suggest this, when you look harder at the privacy interest that's being asserted here, first, leave to one side, there's an assumption that the family's going to watch the documentary. Let's just leave that to one side. That's questionable, I would say. What are our alternatives? There can be actors who will be given unbridled dramatic license to do what they will with what the transcript says. Nothing any of us can do about that. That film's going to get made. No suggestion, no reason to believe that that's any less upsetting, might be more upsetting, again, assuming the family's going to watch it. She's not on the tape. What it really boils down to, I think, is...
But her mother is, isn't she?
Her mother, as I say,
grandmother.
the family witnesses are three: the victim's mother and the two maternal grandparents. Let me stop there, though, for example. 5 other witnesses in this case. 2 experts, two doctors testify, and there's a tape that exists, and no one can hear it. There was a disturbance when the verdict came in that is partially reflected. That actually is probably responsive to Your Honor's question. That's one thing we do know, that there was a disturbance. There were media reports about it, that 2 family members were taken into custody for shouting.
But that's something a spectator could have seen.
Yes.
But let me ask you a question, though. You know, you're basing a lot of your argument on the fact that a lot of this is already in the transcript, and the transcript, it's already public information. Now, I'm assuming that the transcript was released or made publicly available without the family having had a chance to say anything about should it be redacted to protect the youngster's privacy. Now, I don't know if that could have been done legitimately to, you know, redact names. Okay, we'll release the transcript, but we're going to release them without the names. Could that have, because if that were possible, and there could be an assertion of a privacy interest in that context, why couldn't then the same thing be done with respect to the tapes?
Well, certainly there's an option as a practical matter with the tape, which was not explored, which is, let's look at, I still say those 5 other witnesses, there's no conceivable privacy interest there. But let's look at the 3 family members. As a practical matter, surely one could do that, just as you can do with the transcript. Also, as a practical matter, Mr. Audette is not using the first name. I mean, these names are known. There was a public trial. There were press reports about it. So at a certain point, we're pretending. But Mr. Audette is not going to use the victim's first name in this at all. But the family names are out there. It's in this courthouse. Anybody can walk up and see it.
Now, if I could turn to Rule 1.1119, the committee, I think you're even on it, labored to try to find an appropriate balance. And as I understand it, as part of that balance, you would not be permitted to go into a courtroom and audio record without the permission of the judge, and unless you demonstrated that you have some press credentials, albeit maybe even a blogger, and you could not record sidebar, and you could not record a voir dire. These tapes will have all the sidebars and all the voir dires, will they not?
Absolutely.
All right. So if you're right, then this person who would not be allowed to do that morning, at the end of the day, can say, I order the tape recording of it, and at 5 o'clock can walk out with the very same information that they couldn't have had under Rule 1.19?
And there's a very principled distinction between those 2 situations. In one situation, a court reporter, an officer of the court, is as part of her official duties preparing a record. The Rule 119
But
deals
under the
with...
statute, you would agree under the statute that tape is not the record once the transcript is done, right?
It's not right. It's not the quote unquote official record. Again, so there's 2 things going on here. One is, with respect to your question, Your Honor, there is a principled difference between what do we do. Albano wants to come in and tape a trial. Does he have to ask first? What's he going to do with it? It's in his possession. It's a Barnes type situation. Totally different set of rules when a court an officer of the court, statutorily, an officer of the court, pursuant to her duties, has made a tape. Now, that tape, as Justice Botsford said, is not the official record, but here, now, I'd say there really has to be a functional analysis here.
But the functional analysis is, at the end of the day, the person who did not follow 1.19 but asked for the tape at the close of the day is going to walk out with more information, and information that they couldn't have had if they had walked in at 9 o'clock and said, I'd like to do this. I mean, isn't that sort of a peculiar result?
No, and for this reason. Rule 119 is designed to deal with private parties coming in and making their own records of court proceedings. There are documents, I don't get to accompany the judge when the judge makes findings of facts and rulings of law, but once that judge makes those findings of facts and rulings of law, they are presumptively public. In one case, the court, official court...
Judges' notes aren't.
True. But again, we're looking at, nor have there could be notes that the stenographer makes.
But this, in a way, is like that, isn't it?
Well, it's not for this reason. This is a record. I mean, if we step back and say, first of all, we're asking ourselves, what is the public entitled to in order to evaluate a trial? Man convicted of a life sentence. Currently, I learned federal Hague petition pending. Was it fair? Will the verdict be accepted? If it's not going to be accepted, then will there be some movement for reform? We have a tape of what actually happened. And, 1,000 lawyers can get together and say, you know what, it's not admissible under Rule 5452C. But that is not the First Amendment analysis. The First Amendment analysis what did the Pokaski court hold? That a tape recording of a trial is subject to the public's First Amendment right of access, because historically, records of trials have been public, and because it plays a positive role.
You're going to have to wrap it up.
Thank you.
Thank you.
Thank you.
May it please the court, Fawn Bolero Anderson, Assistant District Attorney from Middlesex on behalf of the Commonwealth. To be clear, the filmmaker in this case isn't being denied access to any information. He can get access to the same information through the transcript that is otherwise on the court reporter's audio recording.
And what's the problem with releasing the recording?
First of all, there's a few reasons that there's a problem with it. We have to look at, Judge Tutman was correct to question whether or not this was a judicial record. We have to look at the background of how.
So if it's not a judicial record, then how can she order it not to be turned over?
That's correct. She could not. It would be within the court reporter's discretion whether or not she would turn it over. In this particular case, we know that the filmmaker went to the court reporter, asked to purchase a copy of the audio recording, and she said, I'm not going to release it without a court order. And that's what brought us to court.
Now, the court reporter, though, is a court employee.
She is an officer of the court, a sworn officer of the court. That's correct.
Not only an officer of the court, but she's paid by the court as an employee. I mean, attorneys are officers of the court, too, in some fashion, but they're not generally paid by us.
A court reporter is almost treated as an independent contractor, but however, they are paid by the court.
Now, would it be different if this were in district court, where the only record of is going to be the tape recording, and which are often, I gather, given out if there's a request for it?
It would be different in that we wouldn't be looking at the question as to whether or not this is a judicial record. But in district court and in some superior court proceedings, there are recordings made under the control and supervision of the court, and they are considered judicial records. But in those cases, a party who is requesting that tape must make such a request. There are forms in the clerk's office. They fill out the form and they make that request.
So if this happened to be in a courtroom which did not have a court reporter but simply had the new taping system,
Right.
you wouldn't be here.
We would still be here because there are typically, this is a sexual assault case, and I don't think that a clerk's office would release it absent notice to the parties. There is a notice function on the form that says the parties will be notified of such a request, and the Commonwealth would still be asserting its objection. And then there are rules
All right,
that
so,
govern.
so the Commonwealth would be asserting an objection, and what would they have to do to establish that the objection was well made? Just an objection or something else? What's the burden here?
The burden is to show good cause that the
In light of this public court record of a public proceeding and surely presumption of public.
That's correct. That's correct. There is
So you'd have
case
to
law that
present
governs.
evidence? You have to present evidence that this would cause some undue harm to someone?
I wouldn't go that far, because if you look at the line of cases with regard to impoundment. So first of all, backing up a little bit, we have two rules that govern the tape recording, the court's tape recording of proceedings. District Court Special Rule 211A, subsection 6, and then there's also a Superior Court Standing Order 2-87. And both of those rules say that the cassette tape cannot be released for a commercial purpose for public or private entertainment or amusement. That's what happened in this case. So we have this third party coming forward, making a request. The judge can say, we're not releasing this because it's for this particular purpose.
Well, but you still have to worry about whether that's constitutional.
There hasn't been an attack on whether or not that prohibition to the recording, which is in the province of the court, there hasn't been an attack on the constitutionality of that prohibition in this particular case.
But I mean, but the newspapers and magazines are also commercial, as your brother points out. Do we have to sort of evaluate how serious the documentary is, whether it's going to make money or lose money? I mean, what is it? How are we supposed to evaluate this? We certainly don't want to begin to have to look to see whether he's going to be favorable or unfavorable to the court judgment. So what's the criteria to use for that?
I think the difference is under the court rule 1:119, what's at issue there is the actual news media's recording. And we can't, they're given authority to make that recording and to do what they want with it. In this particular case, what's at issue is the court's recording. The court is making a rule about its own recording, saying that it can't be used for...
But let's assume that this is a Superior Court courtroom with one of these machines that records everything, and the Boston Globe or the Boston Herald or the New York Times comes in and requests a copy of the cassette. They're interested in the transcript of the proceeding. You're going to say, no, that's a commercial purpose, no can do?
That's correct. That's correct. Under the rules, the rules are very clear that it cannot be...
That's perfectly constitutional as far as you're concerned.
As far as the court would be able to prohibit how that could be used, and we're not saying that these parties, there's no constitutional right to record.
No, the court has recorded this.
That's right.
The court has recorded this.
The court has recorded.
So the court's made the record. The question is who in the public can have access to it.
That's right. And so then these rules also talk about it can be released, albeit unless it is impounded or sealed. That's when the Commonwealth is coming forward and saying it should be impounded. So not only do we have the rule prohibiting the use in this particular case, but we are asking that it be impounded, and it was
And the
impounded.
reason for the impoundment is what?
So we have all our rules of impoundment. Rule 7 specifically points us to what the court should have considered: the nature of the crime, the type of the information, and the privacy interest involved, and the extent of the community interest, and the reason for the request. Now, the Commonwealth, in its brief and below, relied on a Seventh Circuit case, the Edwards case, which had other factors, but I would submit that these are subsumed within that. The only reason the Commonwealth relied on that case was because it dealt with an audio recording, which was an exhibit in that case, so it had that context to it, but it wasn't necessarily, it wasn't the record of the case.
So let me see. So you're saying that, in fact, there could be somebody who had a legitimate purpose for getting this recording?
For education purposes, perhaps.
For educational purposes. Okay. So a college professor doing a course on, potentially wrongful convictions or something, can request this and get it for that purpose.
Potentially.
If they was going to publish a book about it, though?
It is questionable, but that is one of the reasons, one of the factors that is considered by the court in deciding whether or not to impound it, the purpose for the request.
And you're saying, I'm a little puzzled why you say you don't think that this lawsuit is challenging the constitutionality of those rules if those rules are being used to prevent access to the tape recording.
There is no specific challenge in the papers to the constitutionality of that provision. What they're saying is that it should just automatically be released, and the only potential attack on the constitutionality is on 265 section 24C that says it would have to be redacted, but on the papers, and that is a stretch based on the papers here. All they say is that there wasn't enough to show good cause in this particular case.
It's a constitutional requirement, presumably.
Under Silva, this court said that it's essentially the same factors as required for impoundment as are required by the First Amendment. So what the court has to look at is the competing rights of the parties and the alternatives to impoundment. And that's what the judge in this case did. She, under her, we have a...
Did she listen to the tape?
She did not.
Was she the trial judge?
She was not in this particular case.
Well, then how can she do that?
Well, what we have here is we had the appeals court decision when the conviction was affirmed, and we can see the details of the testimony that was involved in this particular case.
But the transcript is
So let
me just on the impoundment. I mean, impoundment is not usually something that is forever, and needs to be rejustified over and again. So even if you had, so somebody gets it for educational purposes, are you saying they can't pass it on and do something else with it?
Well, that would be prior restraint. And once somebody has something, it's a different analysis. You have to come forward with that compelling interest to overcome that. This is different. This isn't in the possession of the third party yet. This is the Commonwealth coming forward and saying that this should be impounded. The judge finding good cause to do so.
Impounded as to this one individual.
As to this one
requests it.
individual and this one purpose, not indefinitely and not to everybody.
So long as he has this purpose, this improper purpose under the statute.
That's correct.
He can't have it.
That's not just under the statute, but in light of all the factors. We have a child rape case here where there's sensitive,
But you've already got the transcript released, including the name of the child.
That's right. So it's just whether or not the added value of the having access to the...
Is that his burden or yours?
Under the fact, it's the
You say that there's not much difference. And ordinarily in First Amendment analysis, it's the one who seeks to have closure or non-access who has to justify that.
That's correct.
Not vice versa.
That's correct. But one of the fourth factor is the purpose of the request. So when I argue about the purpose and why the filmmaker is seeking access to this, it's in light of the factors. It's not saying that he had the burden to say, there's a presumption that it is open to the public and accessible to the public. What I'm saying is that we have to look at the good cause finding in this particular case in light of the purpose that was set forth by the requester. It's right there in Rule 7 of the impoundment.
Now, before I thought you said this is a backup by the court reporter. It's not available as part of the public file. You can't go through the docket and find it, and therefore there is no constitutional right to it. And now I hear you speaking about a constitutional right. What is your position as to that?
It does get a little muddy because we have so many cases. In this particular case, it is not a judicial record because it was made by the court reporter on her private equipment, precisely, and kept in her possession and not under the court.
Now, when you say private, who actually purchased that equipment?
The court reporter.
Okay.
The court reporters
who purchased the tapes?
That's an interesting question. That's not in the record. I would, based on my assumption that they're required to purchase their own equipment, that they would also have to purchase their own tapes because it's essentially, I don't know who purchases her paper when she's taking notes either. But regardless, this falls under a stenographer's notes.
Yeah, it's so complicated, though. Suppose she were to get ill or die or something, the backup tape and her own
Voiceover.
whatever you call it when they speak into the mask, was there. That would be owned by, if it was really just hers, then what? It would be owned by her estate, and the court wouldn't have any control over it?
Well, typically what happens in those situations is that those materials are given to the head.
Yeah, but I mean, I don't understand the legalities of all of this.
I'm sorry, could I just find out what was your answer? They're given to the who?
Rich Parsons, in this particular case, takes possession of them
The
and then
Superior
reassigns
Court official takes possession of those tapes.
That's practically what happens. It's not in the record.
Well, where are they kept? I mean, do they go into the person's house and take them, or are they typically the estate turns them over? Does the Commonwealth pay the estate for that material?
I'm unclear as to. I think they actually do have to go into the person's house. I'm not sure how they facilitate that process because
Is this
unless
governed
they have
by
an office.
statute, by regulation, by contract?
It could be in the contract. That's not part of the record as to if the person leaves or dies, how they can be granted access to their private.
So you're saying it doesn't go automatically to Rich Parsons?
No, I'm not saying that. But practically speaking, that's typically what happens.
It does go automatically, practically speaking. It doesn't.
I'm not sure. I can't say for sure. But I know that in cases where court reporters are gone, he ends up with them. I'm not sure how or why.
But certainly the court does have the ability to insist that it be available for review if there's a question, say, as to accuracy or if there's a missing part of the transcript. So the court certainly could say to the court reporter, as an employee, make that available to the attorney so that they can challenge the accuracy of a question part of the transcript.
Right, that's correct. In the same way that the judge's notes can also be consulted when there is an inaudible or there's a question, but that doesn't make the item or document being consulted a judicial record in the same way that the judge's notes.
Maybe because the judge chooses to use them. I don't think anyone's going to order a judge. Well, that's a separate issue, but.
Yeah.
Okay, so what are these things? And I guess, are they different depending on what the technology is that's being used? I mean, do we have two different rules? One when we have a tape recording system and one when we have a court reporter system?
I think in this case there has to be two different rules, and that's because of the dangers involved with the court reporter audio recording. It can't be released absent some kind of rule from the court that there should be, the court or somebody needs to be reviewing what's on that tape to make sure that confidential information, work product information, attorney-client information, inadvertently recorded information, sidebars, all that isn't released to the public.
Well, sidebars would be released. They're part of the transcript.
Right, but I mean, the court, somebody's saying you're giving the public a broader right to access than they otherwise would have been entitled to, as you noted before. So there has to be something in place. But if I could just move back to the good cause analysis, I don't think that the Commonwealth has to prove in this particular case, in light of the fact that it's 5 years, that the victim's 8 years old currently, and the dangers that are involved, the re-victimization. Not only is this victim at issue, but there's other rape victims and other witnesses who testify to witnessing crimes. The use of their voice in a film is assaultive and re-victimizing them. And I don't think that you need, that the judge was entitled to take as part of her good cause analysis judicial notice of the human nature behind that in this particular case under the facts of this case.
Thank you.
Thank you
No further
very
questions.
much.
I'll rest of my brief. Thank you.